Okay, before we follow on to the actual court hearing for this case, Crichton versus the Ministry of Justice at the High Court on the 1st of November 2023. We're just going to go through some relevant documents leading up to the actual court hearing, and so the documents you will see in this episode are the documents that were the judge had given us a schedule to follow. Okay, you will also see the minute of Judge Brighton dated the 30th of August 2023. But before we go to the next episode, which will be the continuous of this, but it will be on the actual hearing, what actually happened at the hearing on the 1st of November. But I just wanted to do this clip because I feel that this memorandum is actually kind of relevant. Well, it's actually relevant to the case and things that were verified at the court at the court hearing for the case management conference on the 1st of November 2023. So this memo I have in front of me is called the Applicant's Memorandum in Response to Joint Memorandum for Initial Case Management Conference Request sent by email on the 20th of July 2023. Actually, before I read the memo, let's see if I've got it here. Here it is, right here. This is when the Crown or the Council had initiated a conference hearing because they'd already made their submission of their interlocutory application to strike out my application. However, I had other court proceedings before that, hence is the reason why it took a long time for me to actually respond to the application. However, the Crown or the councils initiated the case management conference with the courts. So they put in a joint memorandum, you can see it right here, this is the councils, a joint memorandum for initial case management conference. So they made that submission. These are just, I won't go through what they wrote. They basically just wanted it to go to the next level to get it moving. So they initiated it and they sent me. So this is the new, why I feel this is important, because this is the new court process that I'm not used to. Okay, so this is new to me too. And so what has actually happened here, the council has actually initiated a case conference hearing with me and notifying the courts, meaning they've sent me this memorandum and making a suggestion. There was an actual hearing date set down by the courts for the 28th of July 2023 to go forward, but I've actually notified, because at this stage, at this time when the council submitted this case management conference to the courts, my interlocutory application to enter a summary judgment of liability wasn't ready yet. So I just thought this is really important before we follow on to this on this episode, which is episode 4 for this court case. So let's go back. So when councils made that submission, I put a memorandum here, which is what I feel is really important to my case, notifying the courts in response to the council's memorandum and wanting to initiate. So it's called a case management conference hearing. That's the first hearing of any court cases that proceeds in the court. As you can see, This is my memorandum, and it's stated the 28th of July. That was scheduled for the next hearing by Judge Brighton. So I thought it was relevant for me to read this memorandum because it's sort of like a confirmation that everything I said in the courts I did. The other documents you will see I've actually typed out. I will get onto that a bit more and explain about those other documents, but I'll just focus on this one right now. So this one here, I'm just going to read the memorandum because I feel it's relevant to the whole case, and just basically confirmation that everything I said I did. Okay, so I've written here, may it please the court. I will actually read what it actually says. Okay, may it please the court. Number one, on the 30th of May 2023, Counsel S.K. Shaw and C.R. Craig, A. Interlocutory application to strike out the statement of claim dated 9th of February 2023. B. Affidavit of Sean Graham Hayward in support of application to strike out statement of claim dated 9th of February 2023. Number two, on the 15th of April 2023, the applicant notified the courts by email that she was going to submit an interlocutory application to set aside judgment. The applicant will be submitting an interlocutory application under section 12.2, 12.3 and 12.4. The email was sent to Sione Fifita email, and it's got the case officer's email details right there, and it was sent on the 7th of July 2023. I sent an email to Sione Fifita's email address, and I received an email response from him stating that I am no longer working. So the case officer had actually left, but before he actually left, we confirmed the process of the next step, because when I received the council's application, which is stated here, if you can see the arrow on A and B, I had made the decision that I was going to do an interlocutory application to enter a summary judgment of liability, because I knew that the Crown or the Ministry of Justice had no case to answer, meaning they have no evidence, or they couldn't even challenge my case even if they tried. So you got to be pretty confident with things like this if you're going to go down that route with the court process. But because it was my case, I was pretty confident that they couldn't challenge it even if they tried. So I notified the court that I was going to that I was actually working on an interlocutory application to enter a summary judgment, and those are the rules there that I've put up here. 12.2 under High Court rules, they are 12.3 and 12.4. okay, now number 3, I'll continue. It says the applicant has had major problems with contacting the courts by phone and email. The courts have hung up or give false information or withhold information, won't give the case officer's contact details, or the case officers won't respond to emails. The applicant went to the High Court on several occasions and have asked to speak to the case officer or to ask the case officer to contact the applicant. The case officer has not made any contact until Monday the 24th of July. So basically during all this time, just like with all the other court cases, I'm being blocked out and everything's being sabotaged. So this is the kind of block out, blacklisted system I've been subject to every single month, day in, day out, to do with my court case. All right. Number 4, on Thursday, the 20th of July, 2023, Council sent an email, a joint memorandum for initial case management conference. The applicant rang counsel on Monday the 24th of July 2023 to discuss the matter in regards to their memorandum. Katie Craig has made contact with the applicant on the same day. That's the counsel. Number 5, the High Court Rules 2016 under Rule 7.35, the registrar that is supposed to contact the defendant and the plaintiff. The court has not advised the applicant of any hearing date that has been scheduled. An email was sent by the case officer on Monday the 24th of July 2023. So basically, I'm just notifying the judge that the process that I'm used to. All right. So if you're keeping in mind, I'm the applicant, and the counsel's representing the defendants. Let's carry on. The applicant has consent with counsel to have a CMC on the Chambers list on the 28th of July 2023. Okay, so the usual court process that I'm used to, or even according to the legislation, is that the case officer is supposed to set the case management conference. But I did notify them that, I was working on an interlocutory application, and obviously I needed time. Plus I had all these other cases that I was going through with the Ministry of Health and City Med case. So that was the hold up, but I did notify the courts about it, and they knew about it. So carry on. And then I just carried on and just wrote in the memo just to let the courts and the judge know. This memo was actually addressed to the judge. The applicant's current position, number 7, the applicant currently has other matters that coexist with this case. The case are as follows: Ministry of Health and City Med, and I've put bracket judiciary review application, and then that's just the CIV number there. And then B, I'm just listing the cases: Public Services Association, and that's the union, PSA, New Zealand Police, and Independent Police Code of Conduct. So in total there are 1, 2, 3, 4, 5, 6 in total government organisation, okay, in one case. They were all lodged on the same date that the judiciary review, all the applications were lodged together with the judiciary review application. And I actually specifically asked the courts, and it's actually in the judiciary review application, that I wanted these cases to ride together because they all coexist together. It didn't make sense to separate it, because it was I'm a one person, and it was my profile, and all these incidents had occurred to me, being I would be classed as victim of crimes, right? But I'm also representing myself. So it only makes sense that all this follow a suit together, and the old court protocols system, that is what usually happens. In fact, it is still there, but they didn't do that with my case. Those rules still there and apply even now. I mean, what I've gone through should never have happened, but it has, according to the court rules, that is. Then number 8, the applicant is currently in the process of working on her submission in response to counsel's interlocutory application. The applicant will notify the courts and the counsel at the next hearing of the position of those applications. It is possible that the applicant may need more time to complete her application. Okay, so this is the memo that I forwarded to the judge. I've actually typed out the memo in regards to the judge's response to the council's initiating the case management conference, because they just wanted to push it forward, but my application wasn't ready. So that's the reason why I put this memorandum to the courts for the judge, and then judge made a decision on the memorandum. I've actually typed out that memorandum. However, this is the new age system. So I followed through with the application, and then so with that I just responded to the Crown's application according to the schedule. Now I'm just going to walk you through with the minute of Associate Judge Brighton. This is the first minute made by a judge for this case between my employer and myself. So this is the actual minute that the judge made in chambers, and the judge is Judge Brighton, as you can see here, the arrow. And he made this decision in chambers. As you can see, they've got the spelling of my name incorrect. So I wasn't happy about that, because they had it all right, and then all of a sudden they started making spelling errors like the spelling of my name. I did notify the courts about it, and I did put it in a minute. I specifically asked the courts and the judge to have my name amended, the surname, the spelling of it. You can see they've spelled it CHRICHTON. All these kind of things are actually really, really important in your personal profile, because I have found historically, people making these kind of errors, but you need to get them changed immediately if it happens. So the judge made a decision on papers in chambers. As you can see, he's put here the minutes, says he put it on. The hearing was on chambers, which means he excused us from appearing, and he was satisfied to make a decision in chambers. And this is the minute, and it was dated the 26th of July 2023. So I thought it was just really important to actually read this out. Okay. Number 1, this proceeding was scheduled for call in the Chambers list on the 28th of July 2023 at 2:15 p.m. Number 2, the defendant has filed an interlocutory application for an order striking out the claim. The plaintiff opposes their application but has not yet filed a notice of an opposition. The plaintiff is self-represented. Number 3, the defendant's application for an order striking out the proceeding requires a fixture. I set the application down for a half-a-day hearing on 1st of November 2023 at 10 a.m. The application will be heard on that day, regardless of whether the plaintiff has filed any documents in opposition. So you can see there that the judge has set down an official case management conference, half-a-day hearing for the 1st of November 2023 at 10 a.m. Number 4, I make the following directions in respect of the hearing. A, the plaintiff shall file and serve any notice of opposition and any supporting evidence by the 25th of August 2023. B, the defendant shall file and serve written submissions and authorities and a bundle of the relevant pleadings and affidavits by 11 October 2023. C, the plaintiff shall file and serve written submissions and authorities by 25th of October 2023. No other directions are made in respect of substantive proceeding. The call in the Chambers list on 28th of July 2023 is vacated and appearances are excused. And so this is the minute of Associate Judge Brighton. Okay. So this is the very first minute. I just thought it was actually relevant to actually go through this minute before we go on to the next episode, which will be the actual oral hearing on the 1st of November. So what I'm going to do is I will be writing down on this channel the actual applications by the Crown and my application in submission. Now, this is really important. You'll see why at the end of the whole case. I'm one person, and I'm fighting for my liberty here, and I'm fighting for my rights so I can put closure to things and move on with life, but I haven't been able to. And I also just knew that I couldn't really go forward until this court case was legally over properly. Another side note, when the Crown put in their submission, I didn't even bother. I didn't bother apply or responding to their application because I didn't see the necessary of doing that, because I was relying on the judgment of liability to finish the case, right? And that is the proper court protocols. When keeping in mind it is my application. So with that, I then did the reasons why I didn't respond to the council's notice of opposition was because I believe they were going down the wrong avenue, and I had a problem them being the defendant and them calling and telling me what to do when they're the opposition. So there was no fairness as far as the courts. There was no division. It was all one-sided. So that was the cybercrime that I've been subject to historically. So I will just write down all the applications that was submitted to the courts on Friday, the 25th of August. So I will have that those documents written up. I had a feeling that the opposition were going to try and, for me not to use my interlocutory application. They wanted it to not be used at all. So I got that feeling going on with what happened on Friday, with what actually happened on Friday, the 25th of August, 2023. For me, it was important. I wanted my interlocutory application to be sworn. The judge talked about it, and then he spoke to me, and I made it clear. I was very assertive, and I was adamant. It was very important for me to make it clear to the judge that I wanted my interlocutory application to enter a summary judgment of liability to be sworn, and that it was actually the core foundation of my whole case. And this application had everything on it. But I made it clear to the judge what that application was, that I was actually asking for a judgment of liability, and that I actually wanted my documents to be sworn by the Deputy Registrar, and the bundle of exhibits that went that aligns and goes with it, plus another affidavit. With that, I followed the schedule. I responded to all of the council's application, each one, and I will put up the names of each application on this clip so you can see, and I feel this is important, all this information. And this is the new age system, okay? Keeping in mind, my privacy's gone. People are being used on behalf of the opposition, and they're inciting on TV. So it's like I turn my back and they're sabotaging, things go missing, or they're playing mind games, and then they're trying to make out that I have a mental issue, which I don't. I'm just being personally attacked by a criminal alliance. So I will put up on this clip all the documents that was submitted, and my response and council's response. I'll just put the names and you can see it. You decide whether my case is a criminal case. Over the years, in the early days, I had a lot of good people in my life watch over me, and then, you know, then you get the other alliance. I had like a love and hate alliance going on secretly. But what has happened is that eventually all the negative people, or all those that are racist anyway, and when there is something that's turned into like a game, you know, all their family and friends all gang up too. So that's what's actually happened, and eventually the good overweighs the bad, or the bad overweighs the good. And in my case, the bad eventually overweighed the good. So everybody move on with their life, and nothing, you know, I can't sort of just like go on and have a normal life, because you always have to watch your back when you're targeted, because over the years I have found that they keep resurfacing my circumstance and they attack you again.